So some relief for accused number 3 Mthobisi Mncube, who has been incarcerated at C-MAX at the Kgosi Mampuru Correctional Centre since 2020. So the High Court has found that Mncube has been detained in that section unlawfully beyond 18 months and should be removed.
Although the first applicant says that his incarceration amounts to torture in terms of Rule 43 of the United Nations Standard Minimum Rules for the Treatment of Prisoners, the so-called Nelson Mandela rules, his case really hinges on the allegation that his further incarceration at C-MAX is in conflict with the respondent's own standard operating procedures that only allow for the incarceration of a prisoner in C-MAX for 18 months, save in certain exceptional circumstances. The first applicant has been there for 4 years. In my view, if a prisoner is incarcerated unlawfully, an application to rectify the position is inherently urgent. I will deal hereunder with the averment that the first applicant is unlawfully incarcerated. The first applicant has also alleged that the conditions under which he is incarcerated have caused him to suffer a mental breakdown. The allegation is denied by the respondents in a perfunctory manner, but they have made no effort to investigate the first applicant's complaints. I do not believe that the first applicant's averment should be rejected out of hand. I find that, as far as the first applicant is concerned, the matter is urgent.
Well, Mncube's lawyer had argued that their client was detained for 22 hours per day and allowed 1 hour of exercise in a cage and a cold shower in a cage for 2 minutes, amounting to torture. But there's no such relief yet for his co-accused Fisokuhle Ntuli. His application has been struck off the roll. Ntuli has been in C-MAX at Kgosi Mampuru's Correctional Centre since last year.
The same cannot be said for the second applicant. Although he says that he is also the victim of the same allegedly inhumane circumstances in C-MAX, his continued incarceration falls within the 4 walls of the Correctional Services Act 11 of 1998, the regulations and the standard operating procedures. The allegation that the circumstances in which the applicants are held amount to torture is denied by the respondents, and I do not intend to make any finding thereon. In my view, there is no urgency to the second applicant's application. His application stands to be struck from the roll for lack of urgency.
Meanwhile, there's likely to be an additional fight. The two may also challenge the constitutionality of their initial incarceration in C-MAX. This while the main trial resumes tomorrow, with lead investigator Brigadier Bongani Ginindra expected back on the stand. Chris Alder Lewis, SABC News at the High Court in Pretoria.